we talked a lot last year about the fight in individual communities like Enumclaw and Tenino against the placement of sexually violent predators in their communities. And that's not just some phrase I made up. That is the phrase, SVP, sexually violent predator. These are the worst of the worst sex offenders. So in case you're not familiar, Washington State has an interesting way of dealing with sex offenders. If you commit a sex offense, you're going to do your prison time. But if you're deemed irredeemable, like mentally speaking, a psychiatrist has determined that you are very likely to go out and hurt someone else, they throw you on an island called McNeil Island, and you can, because we do have a constitution and civil liberties and all that, you can petition to get off the island eventually. But that petition is really contingent on a psychiatrist determining that you have been rehabilitated, that you no longer are going to be a predator out in the communities. And so anyway, these communities got word that these privately run facilities were going to be housing these people who'd gotten off McNeil Island with virtually no security. They fought back like hell. Tenino won its fight. That facility never opened. Enumclaw, they started fighting after a SVP was already placed there, and then the guy ended up violating shock of the century. Some conditions of his release got sent back to McNeil Island. So anyway, this has been a big topic. We had Representative Travis Couture, who represents the Tenino area, on the show a few weeks ago, because he is working on a bipartisan basis on some bills that would actually kind of strengthen this release system. So you've got more community notification. So we're making sure that if someone does get off McNeil Island, like we are making sure they're not just being plopped in the middle of some community without any notice in a setting that isn't secure, etc. So I was so happy about that. And then, I don't know how this is the first time that we're covering this. One of our subscribers, Daniel, was sort of like in a nice way telling me like, Brandi, what? You kind of dropped the ball. I know Daniel's too nice to actually say that, but that's kind of the gist of I got a message from him. And you're right, I did drop the ball in this because Representative Tara Simmons, it does not surprise me that this is a Representative Tara Simmons bill, a formerly incarcerated person. Wow, I'm using the woke language. Convicted felon, but she's turned her life around. I think that's great. But she pushes a lot of bills in Olympia that are designed to help criminals, even the worst of the worst criminals. She is the lawmaker who pushed the bill that would have reduced the penalty for drive-by shooters who kill someone. She has her name on a bill this session that would make it easier to get misdemeanor crimes, scrubbed from your record. She has a bill this legislative session that would give any judge the power to commute a sentence, basically the power that only a governor has right now. So somebody can be, convicted and sentenced and then petition a judge at any point in the future to get out of prison. Wild, wild stuff. So it doesn't surprise me that her name is on House Bill 2178. And what it would do is it would give even level 3 sex offenders, worst of the worst, the ability to get a release from a lifetime of community supervision. You have some sex offenders in this state who are going to be on those sex offender registries and community custody for the rest of their lives because of the seriousness of what they've done and because of their likelihood to reoffend. I mean, that's why we categorize sex offenders in that way, 1, 2, 3. So we know, and community members know, if they ever end up next door to them, what kind of person that you're dealing with. So I'll just read you, and Nicole, you can pop that back up. House Bill 2178, it says individuals, it's described as an act relating to establishing a pathway off lifetime community custody for individuals with sex offense convictions. It says individuals who are recommended as risk level 2 by the end of sentence review committee upon their release from confinement may be eligible for discharge from community custody 10 years after their return to the community if they meet the eligibility requirements and have not committed a disqualifying event. Individuals who are recommended at risk level 3 by the end of sentence review committee upon their release from confinement may be eligible for discharge from community custody after 15 years of their return to the community if they meet the eligibility requirements and have not committed a disqualifying event. And essentially what that's saying is that after 10 years for a level 2 sex offender, 15 years for a level 3 sex offender, you're kind of scot-free. And you get all that, you get to move on with your life as if it never happened. And the only stipulation is that you haven't committed a disqualifying event in that period of time. Okay, so what is a disqualifying event? It goes on to say, for the purpose of this section, disqualifying event means the individual has been found guilty of any serious and risk-relevant violation of the conditions of community custody as determined by the board at an on-site hearing. The department shall adopt rules defining serious violation. Yeah, this doesn't scream of like government bureaucracy. The individual has been convicted of any new felony offense or any misdemeanor sex offense as defined under state law. The individual has not completed all recommended treatment required in the judgment and sentence board conditions, blah, blah, blah. So essentially, if you're a sex offender, even the worst of the worst, like unless you've committed a new sex offense, which would send you back to prison, so then community custody wouldn't even be an issue anymore because you'd be back to prison and you'd be starting this process all over again. So essentially, if you just don't do that, then you get to move on with your life after 10 years if you're a level 2 sex offender, after 15 years. And look, this definitely... I've always said this about the McNeil Island issue and the sex offender issue as a whole. I get the sentiment of people who are like, lock them up on an island for the rest of their lives. I even get the sentiment of, like in Florida, where they have instituted the death penalty for people who prey on children. I mean, I 100% understand that sentiment, but we don't have the death penalty for sex crimes in Washington state. And so I believe in civil liberties, and you can't just take someone and lock them up on an island or put them in prison for the rest of their life because their crime is so egregious. That's not what our law allows for. But that doesn't mean that for the rest of their lives, if they have committed a heinous crime against a child or another person, that because of the nature of that crime and the predatory nature of the crime, we don't keep eyes on them for the rest of their life, especially if they were on McNeil Island for a period of time because they were deemed by a psychologist to have a high risk of reoffending. I mean, level 3 sex offenders in particular. So anyway, Nicole spent some time. God bless Nicole. As I said, 844 people signed up to testify for this bill, the vast majority of them in favor of it. And I was sort of like, what? I had to read it twice. The vast majority in favor of this bill. There were just a couple cons. And everyone who was allowed to testify based on what Nicole listened to were all in favor of it. But there was one point, before I get to, I'm going to play some clips of the people who testified in support of it, because I want to hear them out, because I'm kind of curious, like, why are so many people supporting this? But before we get to that, Republican Representative Mossbrucker asked one of the policy board members who was there testifying about the offenders who right now are under supervision for life. Like, is there a reason to let them off supervision? Like, maybe it's, Brad, who was in college and slept with his girlfriend who was in high school, and like, yeah, that's bad, but maybe that's a mistake that doesn't have to follow them around for the rest of their life. So here's what the policy board member told Representative Mossbrucker.
So what type of crime would you have to do as a sex offense in level 2 or 3? Who are the people we're talking about?
So we use that individual risk level. So somebody can commit communicating with the minor for immoral purposes and be a level 3. So that offense, which is a class C lower level offense, doesn't mean that that person can't be a very high risk. What I will say is that those individuals who are 2s or 3s are more predatory. They've committed their offenses against strangers. They've committed multiple offenses. They've reoffended. That's why we felt that the longer periods of community custody based on the level was probably the most accurate way to capture that risk and sort of look at it based on those levels.
Yeah, those are people who are more predatory. And he makes a good point there, that the level of classification for sex offenders does not necessarily equate to the seriousness of their crime. I mean, I would argue all sex offenders are serious, but all sex offenses are serious, but it is on a sliding scale, right? But you could commit a sex offense that is at the lower end of that sliding scale, but you could still be a level 3 sex offender because they believe that you have a predatory nature, and either you've already reoffended and you've committed multiple offenses, so it shows you can't be rehabilitated, or you're at, they deem, a very high risk of reoffending again. And so these are the kind of people, by their own admission, who they're talking about giving them a path off lifetime community custody. So in the interest of undivided and hearing people out, more than 800 people signed up at least to testify in favor of this bill. Nicole put together a little montage of some of the advocates, former offenders, and even one victim who spoke out.
One of my jobs was, especially in family cases, was to make sure that this person would stay alive and would have hope. Just imagine that I've been able to convince you to do that, to do all the things that you're required to do. You get a new probation officer, and I've seen this, and for violations that are not hands-on offenses or something, someone goes back to prison and destroying whatever businesses they had or all the things that they had gotten back in their life.
Risk does not last forever. People change. There's no such thing as zero risk for sexual offending. The people exiting by the proposed criteria will be no more at risk for sexual offending than the millions of other men currently living in Washington state.
My son was 12 and a half years old when he was charged and convicted with sexual assault of a child. Before he turned 16 years old, there were modifications to sexual assault crimes, which affected his case in that he would now have to register and be on lifetime supervision. My son is 43 years old today. Foregone opportunities, because in the back of your mind, you're always wondering, will they find out about my past?
I come before this body today as a survivor of military sexual assault and the spouse of a person subject to community supervision. That means restorative and transformative approaches that create space for meaningful accountability, promote reintegration, encourage self-determination, and allow individuals and their families the opportunity to build positive lives that are incompatible with reoffending.
It is my opinion that lifetime supervision has served to leave even the not yet 25-year-old young man feeling hopeless, that his efforts are and will never be enough, and that he will never be done. Likewise, lifetime supervision leaves my 78-year-old client with the same feelings of hopelessness, that all his efforts are and will never be enough.
I've been under DOC supervision for 14 years. None of these successes have had any effect on my DOC supervision. I've been under DOC long enough to experience firsthand a constant state of turnover that results in newly assigned CCOs not having the time or process capability to understand my case file. For every assigned CCO I've had to rebuild a relationship based upon mutual trust and understanding, which can take months to establish.
I'm considered to be successful in reentry and low risk. Yet it is still very difficult for me because it doesn't matter how much positive change I've gone through or how successful I am, I'm still under DOC and the ISRB.
Okay. I try not to make any preconceived thoughts about what I would hear. And that's the first time I've heard those clips. Nicole had heard them, but I had not heard them. Heard them. You know, one of my frustrations, I guess, is, and I would encourage people who are inclined to support this to really listen to some of the word choices that are being used by these individuals. You know, that this creates a hopeless environment for these offenders, that it hurts them, that it hurts maybe businesses they have formed, it hurts familial relationships, it makes their life difficult. I imagine the same is true for their victims, and is true and has been true for their victims and will be true for the rest of their lives. For the victims of sexual assault, that it leaves them hopeless, that it's hurt their family relationship, that it's hurt their careers, that it's made their lives more difficult. That's a lifetime sentence for them. Now, we're not talking about keeping every sex offender in prison for life, but we are talking about supervision for life. So when you use words like that to advocate for something like this, hopelessness, hurt, difficulty, there is no respect or acknowledgement of the hopelessness and the hurt and the difficulty that you created for the victims of your crime, that there is no escape from for them. I want to replay, Nicole, can you replay just the first two statements there for me?
One of my jobs was, especially in family cases, was to make sure that this person would stay alive and would have hope. Just imagine that I've been able to convince you to do that, to do all the things that you're required to do. You get a new probation officer, and I've seen this, and for violations that are not hands-on offenses or something, someone goes back to prison and destroying whatever businesses they had or all the things that they had gotten back in their life.
Risk does not last forever. People change. There's no such thing as zero risk for sexual offending. The people exiting by the proposed criteria will be no more at risk for sexual offending than the millions of other men currently living in Washington state.
How dare you? Are you kidding me? You're going to sit there with a straight face, with your bow tie on your committee hearing, and you're going to tell every single man watching who's never committed a sex crime in their life that a level 3 sex offender who's deemed worst of the worst, if we let him off community custody, he has no more risk of reoffending than the millions of men in this state who has never hurt someone in that way? How dare you? Nicole, will you go back and look at, I just want to know what that title was, if they had a title for that person or who that was or what agency that they're with, because I'm not willing to let that one go. That is absolutely unreal. And I don't know what kind of mind manipulation is at play there, but don't say that. Don't insult the men in the state who've never laid their hands on someone in that way by saying that someone who raped a child and gets released is at no more risk of reoffending. Maybe the dumbest thing that I have ever heard uttered in a committee hearing in Olympia in my 15-year career, and that is saying a lot, because I've heard a lot of stupid stuff uttered. Unbelievable. I would also say, to the point that first gentleman made who said it's his job to make sure sex offenders have a will to live. That's your job. That's not our job. It's not the job of the government to ensure that sex offenders have a will to live after they've committed a crime. It's the job of the government to make sure that they're adequately protecting the public from those sex offenders. So I'm sorry, I hope that person has a will to live and to rebuild their lives and to be a law-abiding citizen, but that's not my concern. That might be your individual concern. Who is it?
Dr. Carl Hansen, Society for the Advancement of Actual Risk Need Assessment.
Sounds completely made up.
Yeah.
You shouldn't be a doctor. I mean, that should be like what kind of doctor, I wonder? That should be a hit against your license to suggest that. Incredibly offensive. I'm gonna dig in more into that guy. I don't like targeting individual people, but that's one of the most offensive things I've ever heard. And I would also say of these sex offenders, look, if you are truly rehabilitated in every sense, like you are truly have no desire, no predatory nature, none of that, you're a law-abiding citizen, then you should have no issue whatsoever following the conditions of your supervision. Bottom line.